It's not gonna, I'm just gonna make sure that it's, I assume that we're gonna need to, yeah, so I don't wanna, I just hope it doesn't fall in the middle. No, it's just resting, so we gotta be careful not to touch it. I'm just trying to move this a little so it's not, there we go. Good idea, actually. All right.
The Court of Appeal in for the 6th District of the State of Florida is now in session. The Honorable Dan Craver, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, everybody.
Good morning.
Welcome to a oral argument session of the 6th District Court of Appeal. This is a Law Day event, and this is being streamed live on YouTube, so I guess as a public service announcement, if you haven't already silenced your cell phones, I'd be grateful if you did. But we are appearing in Hendry County in the 20th Circuit. I want to start by just recognizing and thanking both the 20th Circuit, Hendry County, and the Hendry Glades Bar Association, who has just been such gracious hosts for us all the way through. It's nice to be able to see every different part of the district, and it's really nice to be here. Let me introduce the panel. We have two cases this morning, and before I call the first case, let me introduce the panel. To my right, your left, this is the Honorable Mary Nardella, and to my left, your right, this is the Honorable Josh Pratt. The first case today is case number 24-478, Diversified Land Management LLC versus Luis A. Augusto and Melissa Alicea. Mr. Ryder, how much time would you like for a rebuttal?
5 minutes, please. Thank you, Your Honor.
All right, sir. Whenever you're ready.
Thank you. Good morning. May it please the court. Again, my name is Jack Ryder, here on behalf of the appellant, Diversified Land Management. Your Honors, this case implicates fundamental core principles that go to the heart of the issue of proximate causation and sort of the overriding principle that governs that principle of our analysis and the concept of what is improper speculation and inference stacking. It is our position here that when the court examines the facts of this very, it's unique for Florida, but as we cited, there's a multitude of cases from around the United States that have addressed this very specific issue. Under the Gooding principle of proximate causation, it's up to the plaintiff to present those facts that would allow a jury to determine that it is more likely than not that there is some proximate causal relationship or connection between the absence of a smoke detector and the injuries that happened here. And it's significant that in this case, there's simply no way for the jury to have reached a verdict that would have imposed any causal relationship between the absence of a smoke detector and the injuries that Mr. Augusto unfortunately suffered without multiple stacking of inferences and an incredible amount of speculation. And so, for example, a jury would have to speculate in order to reach a verdict here that, number one, the smoke detector a smoke detector would have gone off in time to warn Mr. Augusto, that he would have heard the detector outside while he was in the rain, testifying that he was at least 26 feet away for approximately 10 minutes when he was trying to put a tarp over a cage for his dog. And there's testimony from our expert, Mr. Mason, that the airport, which was only across the street, that there were 18 planes that hour, approximately one every 3 minutes. The jury would have to infer and stack inferences and speculate that Mr. Agudo would have seen the smoke before the fire started, would have gone back into the house sooner, and the issue there, the problem is that the mere possibility that there may have been a different outcome is simply not enough to get to a jury, again, on the fundamental issue of proximate causation without speculation and stacking of inferences. And, you know, the Fourth District explained this in the case of Zoda, Broward Builders versus Zoda, and they said, you know, the purpose of the rule against stacking of inferences is to protect litigants from verdicts based on conjecture or speculation. And this is clearly such a verdict. And, you know, it's important to note here that the plaintiff has not cross-appealed the order that limited the expert, Fleming, the fire expert.
Before you move on to that, I think I'm definitely want to ask your colleague about that line of argument that you just made. I think just from reading his brief, though, the response would be that there was a smoke alarm demonstration in front of the jury, and obviously, you know, we instruct jurors that they don't leave their common sense at the door when they come into the courtroom. You've got a open door to the kitchen, and he's outside that open door. So I think the argument in response was, and I suspect would probably be, unless I'm missing something, would be that based on those two things, this became an issue of fact for the jury. How would you respond to that contention?
Sure. Very simply, Your Honor, our position on that is that you still cannot derive, assuming, yeah, the jury heard the smoke detector, but they heard it inside the courtroom and they heard what the smoke detector sounds like. That doesn't fill the void between when Mr. Agudo, who was outside 26 feet away with extraneous noises and other indicia or you know, between the airplanes and the wind and the rain, not only does that not provide a gap filler in terms of the proximate causal connection between the absence of a smoke detector and the time that Mr. Agudo would have heard it, it also requires the jury to make various leaps. Because, again, Mr. Agudo was outside for 10 minutes by his own testimony. So there is no way to ascertain at what...
Is this Augusto, just to make sure that I'm pronouncing it the right way? It's Augusto, not Agudo, right?
Yes, I apologize.
No
I said Agudo.
Yeah.
It's Augusto. Yes. So Mr. Augusto, the plaintiff, he testified he was outside for 10 minutes. So there's no way, the fact that the jurors heard what the sound of the alarm was like indoors doesn't account for the fact that within that 10-minute span, there's simply no way to ascertain at what point the smoke detector would have gone off, whether he would have heard it, and when in the chain of events it would have gone off such that it would alert somebody outside. And then, of course, we get to some of the most fundamental components of that, and that is this notion that he re-entered the home from the outside. And I want to get to that because I think that's a very significant point, because that really constitutes sort of an intervening event that really cuts off proximate causation.
Yeah, but before you flip from
one
argument to the other, I wonder, and I don't know if you've given any thoughts to any analogies. The only ones that I've been able to come up with are imperfect. And I think what you're saying is, you know, the way that jurors can perceive things in a quiet, well-lit courtroom might be very different than how a plaintiff or a defendant or a witness might perceive something outside and in different conditions. So is the argument that the demonstration wasn't competent substantial evidence of cause because the conditions were so different, or am I missing that point?
No, and so, Your Honor, this is not as much as an attack on the demonstration. I mean, the demonstration did not provide, it did not provide a clear demonstration of what it would be like for Mr. Augusto outside, but that's not really my argument.
Well, yeah, that's my question, though, because could a juror say, okay, I've been outside, I've been in the rain, I maybe even have a dog, and I'm listening to that sound, and that sound is so loud, I know that it's 25 feet or 26 feet away from an open door, although I think the smoke detector, based on the testimony, would have been further than 26 feet.
I agree with that, Your Honor.
So could they just not say, hey, I'm not expected to leave my common sense at the door, I could have heard that?
And I understand, but that's not why I'm not specifically attacking the demonstration per se. What I am saying is that hearing that noise is irrelevant because there's no way to ascertain when the noise would have gone off vis-a-vis the smoke, the fire, and at what point Mr. Augusto would have realized it, and that it lured him back into the property. And here's what I mean when I talk about the disconnect between the demonstration and the causal analysis. It really goes back to their expert, and here's why I say that. When they had an expert, Mr. Fleming, and Mr. Fleming was very, very strongly limited, and plaintiff has not cross-appealed that. And the reason why I highlight that is because Chief Fleming could not testify that if the smoke detectors had been installed, they would have warned the plaintiff before the grease caught fire. He was not allowed to testify that if the smoke detectors were installed, they would have provided or afforded sufficient time to avoid the fire. He was not allowed to testify that Plaintiff Augusto would have had sufficient time to go back inside before the burning grease ignited into a fire. He was not allowed to testify that the smoke detectors would have even alerted Augusto. He was not allowed to testify that Mr. Augusto would have heard the smoke detectors while outside, and he could not testify that Mr. Augusto would have been able to hear and appreciate the significance of the alarm even though he was home but outside. The most important thing to me in that regard is that the judge concluded that Mr. Fleming could not testify, and there's no other evidence in this record to support the fact that Mr. Augusto would have heard the detector before the grease caught on fire. And that's the key.
What if we change the facts of this case just slightly? Let's say it wasn't the 26 or plus feet, it's 5 feet from the doorway. Does that then change the argument? And if so, where are you suggesting we draw that line where it's reasonable for the jury to infer one thing, but now it's too far away for them to use their common sense and infer the other?
Okay, so it doesn't change the outcome, Judge Pratt, because my analysis does not hinge, my argument does not hinge on the idea solely of the inference stacking, the speculation. It also goes to the fact that a person who's outside should not, well, a person who's outside and comes back in voluntarily to combat a fire, that is not, there's no correlation in terms of approximate causal connection between the absence of the smoke detector and a person who chooses to re-enter the structure. Before I go to that with a little bit more, I want to focus on that more specifically, but I just want to say, as it pertains to this issue of the speculation and inference stacking, Chief Fleming, an expert, a fire expert, was not allowed to testify that by the time the smoke would have started to be emitted from the property and that Mr. Augusto might have heard a detector, that the fire may not have already started. And that is the critical point. There's no way to close that inferential, speculative, conjectural gap between when did the smoke start to come out and when did the fire actually erupt. Chief Fleming couldn't say so, and so the jury can't. It was a wild guess. And what I mean by that is that we can, let's assume hypothetically that there had been a smoke detector. And let's assume that the minute that smoke detector went off, Mr. Augusto heard it and ran back inside. Nobody can testify that the fire hadn't already started. It's pure speculation and guesswork. Chief Fleming was precluded from testifying about that explicitly by the trial court, and plaintiff has not cross-appealed that decision. So if the expert couldn't do it, then how I would respectfully submit, then the jury, common sense cannot fill the gap of whether or not by the time the smoke would have started to come out and Mr. Augusto made it back to the house, the fire wouldn't have already started. And so let's turn to this issue of the idea that a smoke detector fundamentally is intended to warn occupants inside a dwelling about escaping, to get out.
Counsel, how do we determine what the purpose of a smoke detector is? Is that a legal issue or a factual issue?
It's interesting, but I would say that whether the court looks at it as a legal or factual issue, we get to the same place, and here's why. The only testimony on that came again from plaintiff's expert, Mr. Fleming, Chief Fleming. Chief Fleming testified, his testimony was that smoke detectors are intended to alert individuals to escape from a fire. And he testified to that at multiple times when he was confronted with this issue. He talked about the testing and the rationale as to why they were specifically utilized. I believe that was here at the record 16302. This is Chief Fleming. The smoke detector is intended to allow a person to escape the zone of risk. The plaintiff's expert testified that a smoke detector is designed to facilitate escape. He said there are no tests that are done to determine whether or not a smoke detector would be heard outside, because that's not what smoke detectors, and that's the factual point.
Counsel, why do you think the purpose of the smoke detector is important? I know you built your case upon it, and there's some old English common law on connecting the purpose of a statute to the actual cause of a loss. But I haven't seen anywhere in the briefing why the purpose is important. I think everybody's assuming that it is and fighting over it. But what would you say to that?
Sure. I don't think that this decision hinges entirely on the purpose of the smoke detector. It goes back to the nature of whether there's a causal connection between the purportedly negligent act of not having a smoke detector and the outcome. The reason why these cases from around the United States, I think, are both illustrative and informative and helpful to the analysis is because we've canvassed and found 9 or 10 different cases from around the country, Georgia, Ohio. They're all in our brief, and we've gone through them, and I can answer any questions about them. But the cases uniformly talk about, in the context of causation analysis, the idea that a smoke detector, at its core, is to warn occupants of a dwelling so that they can escape, not to lure people back in to fight a fire. The reason why it's not so much about the fundamental purpose of a smoke detector mechanically as it is about what constitutes proximate causation. And so each one of these cases, the Alloway case, the Yurdy case, the Wilkerson case, and again, we've listed them all in our brief. Each one of those cases talk about the fact of an occupant escaping, because when an occupant makes a voluntary determination to enter a dwelling, knowing that it's either on fire or that there's smoke being emitted, like many of these cases have very, very facts that are very similar to this one. When an individual makes a voluntary choice to enter a property to fight a fire, there's no proximate causation between the lack of a smoke detector or a malfunctioning smoke detector and the individual's decision to do that. And so each one of those cases looked at it not so much from they did talk about the purpose of a smoke detector, but each one of those cases talked about it in the context of proximate causation, because there's a cutoff, there's an intervening act. It's the voluntary decision by an individual who says, I'm safe, but I make a voluntary choice to enter or fight a fire, and so the absence or presence of a smoke detector has nothing to do with the decision.
But counsel, how's an individual to know whether that's the case unless they go back in? I mean, it could be a malfunctioning smoke detector, as you alluded to. It could be just that smoke is coming out, but no fire is there yet. And at least in the facts of this case, it's not until Mr. Augusto's end that he now realizes there's this fire. I would agree. It'd be much different if you're looking in and you see flames through windows, but there's no testimony to that effect, correct?
The testimony here is that he saw the smoke coming out, he entered, and immediately saw the fire. He wasn't trapped. This isn't a situation where he had to go in and save his dog or somebody like that. It doesn't change the analysis, Your Honor, because the bottom line is, certainly under the facts of this case, if we liken this case, and I believe we can, to the facts of the multitude of cases we've cited, an individual who knows there's a fire but says, I'm going to go in and combat the fire, unfortunately gets injured, and in some of these cases people unfortunately passed away. The decision to do that, there's no causal correlation between the absence of a smoke detector and the injuries that resulted in the case. And that's why the issue is about proximate causation. But as I mentioned, Judge Nardala, whether it's factual or legal, the facts of this case, uniformly, or is that the purpose of a smoke detector is to give occupants time to escape, and that testimony came from plaintiff's expert. I'm in my rebuttal time, so unless there's any questions, I'll save the rest of my time for rebuttal. Thank you.
Mr. Lee?
Thank you, Your Honor. May it please the Court. My name is Brian Lee. I'm representing both appellees in this case. Mr. Augusto in particular, which I'll be talking about because he is the one that was injured in this particular case. I wanted to start by kind of going back to just the core of this case, which is it's a directed verdict issue that's in front of the court. It's whether or not the trial court committed some kind of error in denying a directed verdict. And I wanted to start by this court's decision in Lancheros, where this court was dealing with a directed verdict on causation and specifically said a couple things. One, that directed verdicts are rarely given or rarely granted in negligence actions, especially on causation. And then I wanted to highlight a part of Lancheros, which says, and this court, it was talking after reversing a granting of a directed verdict and said, and I'm going to paraphrase the court, that this court it may not be that you win this, meaning defense, that the jury really believes that this one piece of evidence amongst the mountain of evidence is going to carry the day, but it is not our job to determine that. That's what this court, I'm paraphrasing obviously, found in Lancheros and has found in other cases. And when we look at this case, that is the position the court is in, which is what the trial court was in.
My question to your colleague had to do with what a reasonable juror could hang their hat on as it related to proximate causation in this
Sure.
case. And I think in your answer brief, you called out the demonstration and you called out common sense. Do you have anything else?
Sure. So we talked about the testimony of Judge Fleming, and Judge Fleming said a couple of things.
Chief Fleming?
Or excuse me, Chief Fleming. I'm looking at you and I'm thinking Judge. But yes, Chief Fleming. Chief Fleming said that, number one, well, let's go from the very beginning. It's undisputed that there were no working smoke detectors in this apartment. That's undisputed. It's undisputed, and Chief Fleming talked about that there should have at least been a smoke detector that would have been near the kitchen. Maybe he talked about in the living room based upon kind of how those things go. And so what also did he say? He said that if there had been that smoke detector, first of all, there was plenty of smoke to trip that smoke detector.
Okay,
That
I'm
would have
just
been-
getting to the idea of what is
Sure.
there in the record that your client would have heard it.
Yes, okay, so there is Chief Fleming talked about the decibel level, 85 decibels. He
Wasn't
did
qualified to talk about decibels, though. And what's interesting, and that was a colloquy back and forth
Sure.
as it related to both the motion in limine and also during the trial when his testimony started airing into decibels and sound levels.
Right.
One of your colleagues talked about the concept, and I think this is right, I don't know that any expert said it, but the notion that the further away, the more decibels that you lose.
Right.
Which makes sense, because people probably aren't hearing me out in the lobby right now through that door.
Right.
So I think unsupported, but I guess intuitively correct math thing is that every 10 feet, you lose 10 decibels. So
That's what he testified to.
Yeah, so if you're, say, 30 feet away, you
Mhm.
go from 85 to 75 to 65.
Sure.
And 65, I think, is a lot lower than 85. And because decibels, I know, is a logarithmic scale, it's not just 10 beats lower, it's magnitudes lower. So did you need a sound engineer, for example, to be able to say, hey, in a rainstorm, while wrestling a dog, my guy would have heard this? Because otherwise, I'm not sure in that instance that a jury demonstration is apples to apples.
I don't believe we did, and here's why. So the testimony that Chief Fleming set a baseline of, it's 85 decibels, this type of smoke detector. Now, again, would the jury have known what an 85 decibel sound was if they hadn't heard it? Maybe not, but they did. And so Chief Fleming brought a smoke detector like the one and said, this is the one that is going to be 85 decibels, and played it and let it go off, alert for the jury. Now, the jury can...
We don't even know how far away, though, the jury was from that 85 decibel demonstration because that's not
Sure.
on the record.
No, and-
So
and-
again, like maybe they knew what 85 decibels was in a quiet courtroom, but I'm just wondering about their ability to have anything to hang their hat on for causation when that wasn't the situation that your client was facing.
Sure, and I think that that's sort of the starting point, and this was argued at trial, that if there is a, I guess, reasonable inference that the jury would do in this case, or make, is that they knew the sound, they knew that that's what it would be there. The inference is whether Mr. Augusto would have heard it from where he was. That's the reasonable inference can be drawn. And the inference was, or excuse me, the testimony was that Mr. Augusto said that other than the rain, there were no sounds outside. He testified to that. He did testify there was rain going on. He testified as to the distance between there and where he was going into. He testified that the door was open, so there wasn't any impediment to that coming outside. And so the jury could use that evidence, and the only inference, reasonable inference they would need to make is that, okay, we know what the sound is, we know it would have been done, we know that there would have been, from Chief Fleming's testimony, at the very least 2.5 to 6 minutes prior to that flame going when that would have happened, and their inference is that he heard it. And they could use the testimony, they could use their, okay, I hear it here, I think that it would have been done 20 seconds.
It's an imperfect analogy, so please bear with me on it
Sure.
because it's the best I can do. This is a well-lit courtroom where you're standing 10 feet away from me.
Sure.
Does that necessarily mean that I can identify you 40 feet away when it's dark outside?
No, I would say no. It doesn't necessarily mean that, but certainly this is.
Would it be a compelling proximate cause argument to say, juror, use your common sense. You can recognize them 10 feet away with bright overhead lighting. Therefore, you must be able to recognize them 40 feet away in darkness. I mean, that breaks down, doesn't it? And again, it's an imperfect analogy, but it's the best I can do, and it, I think, illustrates the concern I'm having with your case.
Sure.
Which is that there's no testimony, it seems to me, in the record about your client's ability to hear based on those factors. I'm not going to use the word intervening because that has a different meaning.
Right.
But those ancillary factors, the fact that it's outside the house, the fact
Sure.
that there's this distance, the fact that sound diminishes over distance, the fact that it's raining, that's my concern.
Right, and I understand that, Judge Traver, and what I would say is that at the end of the day, there were, as the court knows, this was argued throughout, and that was one of the things that the trial judge actually talked about. At the end of the day, there are two inferences that could be drawn from this evidence. We get to the point where we know that the alarm would have been going off, that there's enough time to come back in and move the pot before it flames. So the point that we have to do is whether Mr. Augusto would have heard it. And there's an inference that, well, no, he wouldn't have heard it because he was 20 feet outside and there was raining, and then there's an inference that says, well, there's nothing wrong with this hearing, no evidence that there was anything wrong with this hearing. He got up in front of the jury and answered questions, so obviously he could hear. And he said that there was nothing outside that would have tamped down that, and so there's a reasonable inference that he would have heard it. And that reasonable inference is buttressed by evidence that the jury heard. Is it imperfect? No. Did they put the smoke detector 26 feet from the jury and then play it? And no, they didn't do that. But there are two, what I would say, reasonable inferences that a jury could gauge from the evidence. And the case law is extremely clear that when there are multiple reasonable inferences that a jury could gather from the evidence, it is not for the trial court to say which one he's going to choose. That is not what the law says. The law says the jury gets to determine that. And there is enough predicate for each of the things that is the only thing that a jury would have to determine whether he can hear it, whether he could have heard it. There was evidence that they could have in front of them that they could have determined that. It was an inference that they could have drawn from the evidence. It's a reasonable inference from the evidence, and it's for the jury to determine that, not for the trial court. And as this court is sort of stepping into the shoes of a trial court, hearing the evidence, knowing that all reasonable inferences have to be in the light most favorable, taken in the light most favorable to the non-movement, my client, that's why the trial judge ultimately said, I'm going to allow the jury to determine that. And the jury did. This wasn't a situation where the jury took the evidence and found 100% for Diversified and 0 for my client or something. They found 50-50. They found both of them liable. And so the argument that I hear quite often and here in this case is that, the jury should have never done this because the jury could never find liability on behalf of Diversified based upon the evidence. Well, we know they did.
Counsel, what would you say to the question on the purpose of a fire alarm? Is that a question of law or a question of fact?
I think it's a question of fact, but I think at the end of the day,
Does it matter what the source of the duty is, if the origin of the duty is by common law or by statute?
I think we had both in this case.
Did
but
you not get a finding that the duty was from 8351 Florida
Yes.
statute?
Correct.
But you did not get, did the court also find that you had that Diversified owed you a common law duty or just a statutory duty?
They found that there was a duty under the statute. There, as far as common law, that was something for the jury to determine.
When it runs under the statute, is that not a question of interpretation?
It's I think it's an interpretation of whether there is a duty under the statute. But
The statute defines what a smoke detector is. Would we not take that into consideration when determining the purpose?
you could certainly do that. I think that the testimony from I think it's a little different. I saw the testimony a little different from counsel here. Chief Fleming talked about a smoke detector as its primary duty, which is in the name, to detect smoke and to give an alarm when smoke comes into it.
Well,
right.
the statute says it detects particles of combustion.
Particles of combustion. He, as the court probably knows, went into a lot of testimony about what that is and what the different kinds of would be. But yes, that is what it is. It's to detect. There is nothing within the definition, as you've put it, Your Honor, nor how it came out at trial that said that a smoke detector's sole purpose is to get you out. Because there was testimony from Chief Fleming talking about, look, part of when we have a smoke detector is it goes off and we kind of naturally look around to see what's going on.
Well, there's a difference between how you'd react to it and what its purpose is, correct? It could have two consequences, but that doesn't mean they're both its purpose.
That's true. And when we're looking at this case, when we're talking about things like causation, we are dealing with consequences. We are dealing with how that detector was seen. And I think that dovetails into the argument that Mr. Augusto's actions were somehow some type of freakish or impossible thing.
How do we judge that? Is that a reasonable man standard?
I think what the court did is the court looked at it that way, what a reasonable person would do, because the court, and I cited to the what the court said, is that it is not a freakish or improbable, I think he said improbable, thing for if someone hears a smoke detector to go in and see what's going on.
How about to put a pot that's burning underwater?
I don't think it's. I don't think the court went as specific, but my argument would be that the actions of the plaintiff, from the point that the plaintiff's coming in and doing the various actions you're talking about, the jury gets to look at that. That's not something that, as a matter of law, a trial court can, at least my argument, a trial court can say, nope, that wasn't a reasonable action, and therefore you're out. When we start talking about, was that a reasonable action for you to come in and see the pot on fire? Was it reasonable for you to put it into the sink? Was it reasonable for you to put water in it? Those are all whether or not the actions of Mr. Augusto were reasonable in the context of that, and that's what the jury instruction talks about. when it's talking about what it's reasonable care, right? That's what they talk about.
So it
And
can never be a question the judge can take from the jury. ever.
I don't, when we get to
If
the.
a judge thinks it's so unreasonable and it's freakish, they still can't take it from the jury.
No, there are situations, and the case law bears it out, that if a trial court says that this was a freakish thing, I think one of the cases talk about, like, it's like a fourth car that hits someone, that, if it's some kind of freakish impossibility, that there wouldn't have been that line, that a trial court can do that, and they have done that in cases. But it's typically a trial court decision to do that. But the freakish, that type of determination, very rare. And the cases
I think
talk.
the cases bear out they use the word generally. McLean uses the word generally. This is a determination for the trier of fact.
True.
But generally, of course, doesn't mean always.
It doesn't.
And the cases that are discussed in both of your briefs generally doesn't always mean always.
Very true. But what we also know is that on the opposite end of the spectrum, that directed verdicts are rarely granted, right? And so, yes, we're talking about a situation. There's a continuum of cases that, some of them are, that can be done, and then if it's done, the courts like you tell us whether that is a freakish improbability. But we don't have that in this case, because our argument is that it is not freakish, it is not improbable or impossible that if someone hears a smoke alarm, they are going, and they see smoke coming out of the house, and mind you, the evidence in this case, which was in front of the jury, this was not a rich couple. This was a paycheck to paycheck couple that apartment and everything was in it was all they had. And so the jury had all that information to figure out whether that is really something that one of them or a member of the community would have done. And that's what they got given, we believe, properly by the trial court. There was nothing that in this factual scenario that lended its way to some type of freakish event that should never go to a jury for determination. That just didn't happen in this case. And so when we look at all of it, I just in my time left, we cited two cases outside of Florida. There are a couple of cases that I've cited in my brief that are literally almost on all fours with people that have been inside, but have been awakened and have gone and tried to put a fire into the sink, literally like my client did, and the courts in those cases found a directed verdict was not sustainable, or summary judgment was not sustainable. But even if this court just looks at Florida law about proximate causation, about foreseeability, about the things that we ask jurors to do every day, there was nothing in this case that rises to the level of one of those rare cases that directed verdict should have been granted. The trial court didn't do it, and this court should not now. If there's nothing else from the panel,
Thank you.
I'd ask the court to affirm. Thank you.
Thank you. First of all, to this point of whether Mr. Augusto could have heard the noise, let's be clear about that. There was testimony that there was, at least in the 10 minutes he would have been outside, at least 3 planes taking off or landing, because there were 18 planes that hour in the rain, and as the rest of the testimony showed. And Mr. Fleming was asked specifically, was he aware of any studies about a person being warned outside the home, at pages 301 and 302. No, there's never been a study that he's aware of that measured the audibility of a smoke alarm to someone outside the house. He did confirm that the concept of a smoke detector is to be evaluated internally. Mr. Fleming said, I'm not here to testify that Mr. Augusto would have heard the noise, at page 16296. Mr. Fleming confirmed that the smoke detectors are not meant to overcome environmental noise, at pages 16317 and 318. And as Judge Traver, I think you noted this, the court sustained an objection when Fleming attempted to testify about other issues relating to the noise and the volume level and the decibel level, and that was not something that was in this record. So I do agree with the notion, Judge Traver, that the in-court demonstration was not an apples-to-apples demonstration, and it did not account for any of the factors that we have gone through, the environmental noise, the fact that it was outside, the fact that nobody could testify as to whether or not Mr. Augusto would have heard it. But I also wanted to
If there
emphasize
had
the
been a
fact... yes.
situation, and I want to, just because this is what we do, the apples-to-apples things, obviously we can't get it to rain inside a courtroom, or we haven't perfected that technology yet. But if you had a situation where I changed the courtroom hypothetical to, say, 40 feet, you set off the alarm 40 feet away from the jurors, and you do one of those ambient noise machines that could replicate a rainstorm, are you in a bad spot in that situation as it relates to it going to the jury?
Your Honor, no. And this is why I wanted to make that point. The demonstration was clearly flawed, but I wanted to emphasize that it was flawed and it wasn't a correct apples-to-apples demonstration, but my argument doesn't hinge on that. It does not hinge on that.
You've got two separate bases for reversal. You've got the intervening cause, the freakish incident of coming back inside, but then you've got the second one,
The
which
speculation.
is that it's speculation. Would a different demonstration eliminate your second argument?
It's hard to imagine, but I imagine theoretically that the argument as it pertains to the speculation, maybe that one could devise an experiment or some kind of demonstration. But the reason, and again, sticking to the facts of what we have here, and this is the one thing I want to emphasize that Mr. Lee did not address in his argument, and that is it doesn't matter whether Mr. Augusto would have heard it or not, because nobody could ascertain or confirm whether the fire had already started. And that's, I think, a very significant point. All Mr. Fleming could provide to the jury was that there would have been smoke before the fire, and it would have set off the detector. But he could not say, and nobody can guess, whether or not by the time Mr. Augusto made it back to that property, that the fire would not have already started. Mr. Fleming was precluded from doing so, and there's no other testimony in this record. So when Mr. Lee talks about two possible inferences that can be drawn from the evidence, that respectfully is the essence of inference stacking, because you have to say that the original inference can be excluded. There has to be, the original inference upon which you base all other inferences. All other reasonable inferences must be excluded, and nobody can exclude a reasonable possibility that the fire had already started by the time Mr. Augusto made it back to the house, even if he had heard a detector. And that brings me full circle back to the fact that Mr. Augusto, because he was outside, is outside the zone of risk. And when it comes back to the element of proximate causation, that's why I do believe the fact that he re-entered the property eliminates any causal connection here. This is a case where directed verdict is appropriate. The trial court called it a close call, and I ask that this court, as a matter of law, reverse and remand with directions to enter judgment for Diversified. Thank you.
Thank you both for the presentation. We'll take the case under advisement. We'll just call the second case. Take your time and get set up, guys, and we'll call it in a second. All right, our second case today is case number 25-288, Catherine Wyrick versus Millennial Capital Company, LLC, and Grep Southeast, LLC. Are you Ms. Layton?
Yes.
Ms. Layton, how much time would you like for rebuttal? Standard is 5.
5 minutes, please.
All right, whenever you're ready, ma'am.
Great. Good morning, and may it please the court. I'm Shelby Layton for appellant Catherine Wyrick, and I'm here with my co-counsel Joseph Sternberg. This is a landlord-tenant dispute based on Ms. Wyrick's rights under Florida statutes and her lease with defendants. But the trial court compelled arbitration under a separate agreement Ms. Wyrick had with a different company, RealPage, for her use of its software program. As explained in Ms. Wyrick's brief, there are at least 5 independent reasons that the trial court's order should be reversed. I'm going to focus on 2 main errors that the court made here. First, the court was required by U.S. Supreme Court precedent to address the threshold argument that it was not authorized to compel arbitration under Section 2 of the FAA, but it did not address that issue. Second, the court erroneously delegated to the arbitrator the question whether the delegation clauses in the arbitration agreements could be enforced by defendants as non-signatories. Both of these issues come down to the fact that Ms. Wyrick's claims against her landlords under Florida statutory law simply have nothing to do with her contracts with a third-party software provider. As a result, this court should reverse. I want to start with the Section 2 issue. So binding Supreme Court precedent didn't leave the trial court a choice. It had to address whether this dispute falls within the plain text of Section 2 of the FAA before it could address any of the other issues in the case. That's because a court can't compel arbitration of any case just because the parties agreed to arbitrate. It needs a statutory authority to do so, and here Section 2 of the FAA is what would provide that authority. And the Supreme Court has been crystal clear that that threshold determination has to be made even if the arbitration agreement delegates questions of arbitrability to the arbitrator. In the New Prime case, the court explained that a court can enforce a delegation clause only if the dispute falls within the boundaries of Section 2, because a delegation clause is merely a specialized type of arbitration agreement, and the FAA acts on this additional arbitration agreement just as it does on any other. So if the FAA doesn't apply, the court can't compel arbitration of any question, whether arbitrability or the merits. If the FAA does apply, then the court can look at whether there's an enforceable delegation clause and either proceed to decide arbitrability itself or delegate that question to the arbitrator, depending on the enforceability of the delegation clause. Here, as a matter of plain text interpretation, Section 2 is limited to controversies that arise out of the contract containing the arbitration provision. And here, the controversy does not arise out of the contracts with arbitration provision, which are the contracts with RealPage. And it's important to note that the controversy must meet the arise out of requirement regardless of the arbitration agreement's stated scope. So this is a question about whether the FAA applies, not a question about the scope of the arbitration agreements themselves. And this controversy does not arise out of Ms. Wyrick's contracts with RealPage. RealPage is just a software platform. It's not a defendant here. And Ms. Wyrick does not allege that RealPage violated the law or anything in its contracts with her, nor does she allege that defendants violated the RealPage contracts.
There is a tipsy coachman argument that's made in the answer briefs about the notice being sent to your client coming from a RealPage server. I think you addressed that in the reply brief, but I wanted to give you an opportunity to talk about it here.
Sure. So the email came from a email address that had RealPage in it, but it was sent by defendants, and Ms. Wyrick alleges that defendants violated the law by failing to provide notice of the fee in that email. RealPage was just the software that defendants used to send their email. This is no different than if defendants had used Gmail or Outlook or any other email address to send an email to Ms. Wyrick. Just because they use that software to send the email doesn't mean that they can then enforce the arbitration agreement in Ms. Wyrick's Gmail terms of use or her Outlook terms of use.
Is there a difference based on your claims are based on an agency theory, I think, as it relates to the property manager? The property manager wasn't a signatory to the lease, correct?
Our argument is that, on the merits, is that the property manager is a landlord under the Florida statute at issue. It's not at all based on a contractual argument. And Ms. Wyrick, to the extent her claims are based in any contract, they're based in the lease, which provides for disputes to be resolved in court, not in arbitration. And if defendants wanted to include an arbitration agreement in the lease, they could have done so, and they didn't do that here. And so, again, this really doesn't arise out of the contract, and so Section 2 doesn't apply, and if Section 2 doesn't apply, then the court has no power to compel arbitration of any issues here, including the issues of arbitrability. Assuming this court disagrees and wants to reach those issues. The next question is the trial court's decision to compel arbitration of those arbitrability issues without considering Ms. Wyrick's specific challenges to the delegation clause. And so her first challenge to the delegation clause was about the fact that this is neither defendant signed these agreements with RealPage. They're just between Ms. Wyrick and RealPage. And so her argument is that defendants cannot enforce the delegation clause as non-signatories. And the trial court was required by Supreme Court precedent to address those challenges to the delegation clause before it compelled arbitration. And again, that's because a delegation clause is merely a specialized type of arbitration agreement. So if it's not enforceable, the court can't compel arbitration of the arbitrability issues. And that is from the Supreme Court's Renner Center case, which says that if a party specifically challenges the precise agreement to arbitrate at issue, whether it's the delegation clause or the arbitration agreement as a whole, a court must consider that challenge before ordering compliance with that agreement. And again, in the Coinbase v. Suski case, the U.S. Supreme Court confirmed that in that case, there was a question of which contract applied, and the court said the court has to address whether there is a delegation clause and whether that delegation clause applies before it compels arbitration. If courts didn't have to address challenges to delegation clause, there'd be no principled limit here. For example, Ms. Wyrick could sign an arbitration agreement with Amazon and have packages delivered to her apartment, and just because Amazon has a delegation provision, defendants are saying that Ms. Wyrick would have to go to arbitration to arbitrate the issue of whether Amazon's delegation clause and arbitration agreement apply to this dispute, even though they clearly do not. And this is the same situation as we have with the RealPage agreements.
But counsel, I guess maybe it's two different considerations. One, what does law require a judge, a trial court to do or not do? And another is how broad an agreement actually is. And I think here, you agree probably that the agreements at issue are very broad, right?
I don't think I do agree with that. So the RealPage agreement, the one we call the RealPage agreement, which has to do with her application, is both limited to only disputes with RealPage. So on its face, it doesn't apply to this case or any disputes with defendants. So I would say that's a pretty narrow arbitration agreement. And then it's also related to certain disputes that only arise out of aspects of the application process and not the whole, universe of potential disputes. The active building agreement.
Well, it talks about all disputes, including those relating to future events pertaining in any way to your client's application for housing at the property under any legal or equitable theory, including claims for breach of contract or statutory claims.
That's right, but there's...
How would you draw that broader?
So there's a key phrase that respectfully you're leaving out, which is the disputes between you and RealPage. And so the way you could draw that broader is to remove that limitation to only disputes between you and RealPage.
So how does the agreement define what RealPage is?
It defines it as basically a couple different entities, but definitely not defendants. So it's RealPage and its corporate siblings, but not landlords that have nothing to do with RealPage. There's no relationship here other than as a customer between the landlords here and RealPage. They're just buying a software service and using it for just the way you would buy, a Microsoft Word or something like that. And so they're not defined in the definition of RealPage in this contract.
Well, counsel, even setting aside the RealPage agreement for now, looking at the active building agreement, it states any dispute, claim, or controversy, each dispute arising out of or relating to the service, including, and it gives a TCPA claim between you and then RealPage your apartment community manager will be resolved exclusively by binding arbitration rather than a court proceeding. Now, the phrase "any dispute arising out of or relating to the service" is quite broad, and a term including that would seem to introduce an example of such a dispute, not a limitation of the exclusivity of that type of dispute, correct?
You mean the TCPA
Correct.
language?
It says including any TCPA claim, so that's not exclusive to that type, correct?
Sure, so there's a couple issues here. First, there's the question of the scope of the agreement, and then there's the question of whether Greystar is a third-party beneficiary of that agreement, and I want to make sure we keep those two questions separate. But in terms of the scope of the agreement, it includes all types of claims arising out of Ms. Wyrick's use of the Active Building portal, and that would include TCPA claims arising out of the use of the Active Building portal, but certainly isn't limited to TCPA claims arising out of the use of the Active Building portal. And here, this dispute does not arise out of her use of the Active Building portal. There's no allegations in the complaint about the Active Building portal. There's no allegation that the Active Building portal has anything to do with what Ms. Wyrick is alleging here. And so, even though that's certainly a broad provision, if she were suing RealPage over something related to the Active Building portal, it would almost definitely be covered by this arbitration provision. But here, she's suing her landlords under landlord-tenant law, and so even though it's a broad provision, it still doesn't apply to this particular dispute. And again, you only reach that issue if you first determine the separate Section 2 question, which is not about the scope of these agreements, but is about whether this dispute arises out of the Active Building agreement itself. And then you mentioned the phrase about the TCPA, so going to the issue about whether Greystar can enforce that agreement as a third-party beneficiary, which they've argued they can, that phrase is the only place where it mentions the apartment community manager is in the clause about the TCPA claims. And so there's no way to read that provision as intending to benefit Greystar more broadly as to the entire agreement. So even if that agreement applied, Greystar would not be able to enforce it.
But why is that the necessary implication? It's giving an example, but arising out of or relating to the service is the broad category. And so why should we read that example as limiting the broad category when it actually just falls within it?
I don't think it's limiting the broad category, but when you're looking specifically for the third-party beneficiary analysis, you're looking at whether the parties intended to benefit the third-party beneficiary. And because they mentioned the apartment community manager only in that one specific instance, I think as a matter of contract interpretation, it should be read to assume that the parties only intended to benefit the apartment community manager in that one instance. Otherwise, they could have said more explicitly, all claims between you and RealPage and your apartment community manager, and left out the specific limitation to the TCPA. So there's no evidence in the language of the agreement that the parties were intending to benefit Greystar as to all claims in the case. And I'll note that even if it was broader than TCPA claims, it talks about claims against RealPage and the apartment community manager, which is not this case. She's not suing RealPage and the apartment community manager. She's just suing the apartment community manager. So there's, again, no evidence that the parties intended to benefit Greystar, and so Greystar can't enforce the agreement. And yeah, I'll reserve the rest of my time for rebuttal. Thanks.
Thank you. We have two appellees. Have you all discussed how you want to split your time?
Yes, Your Honor.
How are you going to do it?
I plan to argue the arguments that are the same between both of Greystar and Millennial, and then I was going to reserve 5 minutes, if possible, to allow any questions for Millennial that are specific to their issue. But otherwise,
So I understand. So you're going to take 15 minutes and then just ask if there's anything panel related.
Correct, and I'm prepared to address all of the issues that are common to us. There's really only one that isn't, so if there's any specific questions.
Got it.
Is
So
that-
would you enter your appearance, and then we'll
Yes.
get started after that?
Good morning, Your Honors. My name is Kristen Fiore, here today on behalf of Appley Graystar. With me here today at council table is Mr. Rob Vargas. He represents Millennial. And as I just said, I'll be presenting the arguments that are common to both Graystar and Millennial. And if the court has any questions, I'd like to reserve 5 minutes for that for Millennial. Your Honors, the trial court found that Ms. Wyrick entered into a valid arbitration agreement. Given the clear and unmistakable evidence of intent to delegate any questions of arbitrability to the arbitrator,
Counsel, what are the limits to delegation?
so limits to what you can put in a delegation clause, I think it's defined by what the parties, what,
So as long as there's what's considered to be mutual consent of the parties, there's no limitation to delegation?
I believe so, unless, I could probably surmise of a circumstance that's not applicable in this case where you would agree to delegate the issue of whether there's a valid agreement, for example, and under Florida law and United States Supreme Court case law, we know that that's a question for the court. So I could see a circumstance like that, but generally, as, a creature of contract, these are pretty broad. And that's permissible, especially the ones in this case. And
So is the possible injustice from that remedied because of the clarity requirement?
I think so. I think that that has to be clear what the parties are, here we've got Ms. Wyrick. She entered into these arbitration agreements. I know there's some dispute in the record about whether or not she knew what she was signing, but we know that that's not a defense to entering these click-wrap agreements. And so I think she knew that these were broad, or she's charged with knowing that these were broad delegation provisions, and so there's no harm there regarding lack of clarity. And
So really, there's two things for the trial judge. Is there a valid contract, and is this clear?
I think so. I've not seen it really articulated that way, but I think so. I think the question is, one, is there a valid arbitration agreement under state law? And two, is the provision that delegates questions of arbitrability or other things clear? And in these contracts, it was. As Judge Pratt explained, it could not be more broad. And there are several cases from Florida, the 3rd District Court of Appeal that we've cited in our brief, Armis, Krakos, and the other one is Vic Potamkin, which talk about broad language, such as arising out of and relating to, and even go so far as to say that in those circumstances, they can be used to incorporate non-signatories into the question of whether they can enforce an arbitration agreement. And that is a question for the arbitrator under a broad delegation clause like the one in this case. And the other thing that we have in this case, which is very clear in the Florida Supreme Court's Airbnb case, is that both of these arbitration agreements incorporated the JAMS rules. And if you'll permit me to briefly just read what
11B.
11B says, JAMS Rule 11B says, which she agreed to abide by signing these agreements, broadly delegates to the arbitrator all, quote, jurisdictional and arbitrability disputes, including disputes over the formation, existence, validity, interpretation, or scope of the agreement under which arbitration is sought. And key here, and who are proper parties to the arbitration. And so, to us, the inquiry ends there. The court properly decided this was a valid agreement, and then consistent with the clear and unmistakable intent as shown in both the incorporation of these rules and the language that is very broad that we've discussed at length, sent it to the arbitrator to determine arbitrability. And I do, if you'll permit me, want to address the Section 2 argument for one moment. I know we addressed it in our briefs, why we think it's not applicable, but the case New Prime does not stand for the proposition that there is a preliminary threshold determination of arbitrability under Section 2. That a court may not compel an arbitration unless it finds that it arises under the arbitration agreement. That wasn't the issue in New Prime. It only concerned whether a court must initially determine whether the arbitration is excluded under Section 1 before proceeding, which is not at issue here. It's pretty undisputed that this was a contract within the confines of Section 1. So that argument, I respectfully believe, is a non-starter, that the court had every right to otherwise. If we accept that interpretation of New Prime and Section 2, then that basically would displace all these contractually bargained for provisions that delegate arbitrability to the arbitrator, which the Supreme Court has repeatedly found enforceable in the Henry Schein case and the First Options case. So I think taking that to its logical or illogical extension would completely eviscerate all of that very important case law. So, we did put this in the briefs, and you, Judge Traver, you discussed the tipsy coachman argument. While we do maintain that the trial court properly sent this to the arbitrator to determine the questions of arbitrability, on this record, we do maintain that the court can also find that the agreement covers this dispute and with these non-signatories for the reasons that I stated previously. And so if the court has no other questions, we'll rest on our briefs and ask that the court affirm.
One question, Counselor.
Sure.
Could you briefly talk about the second PCA's case in Integrated Health Services? I know that's mentioned in your friend across the aisle there brief. Do you have any way of distinguishing or anything you want to discuss about that case?
So Integrated is an interesting case. If you note, the part that they rely on is in a footnote. So we would, they didn't need to really reach that question, but it is, the court there did say, if I'm not mistaken, I'm trying to find, I don't recall exactly what they said, but basically that the type of language can pertain in any way to the arbitrability. The problem with Integrated, and very respectfully, is I do believe that if it's to be interpreted as they would like the court to interpret it, very respectfully to the Second District, I think that it would probably run afoul of these other United States Supreme Court decisions. And in that case, the delegation clause in that case was not as broad as the two delegation clauses that are at issue here. So that's how we would distinguish that.
And in the four corners of that case, I didn't see, but did you see any mention of the JAMS rules?
No, there's no incorporation that I can see from the case. And so I think that is actually, in addition to the broad language here, as we've discussed, that incorporation is, a clear and unmistakable, two forms of clear and unmistakable intent to delegate these questions to the arbitrator. And I would like to give my counsel opportunity. Do you have any questions for Millennial or? No? Okay, thank you, Your Honors.
Thank you.
I want to just address a couple points. So first of all, the question with a delegation clause, like the question with any other contract, is whether that contract is enforceable. And the court has to decide that question. It's not a super contract where if it's clear and unmistakable, no other contract offenses apply. It's the same as every other contract where you can raise questions about whether non-signatories can enforce it. You can raise questions about whether it's enforceable. You can raise questions about the scope of the delegation clause. And that's exactly what Ms. Wyrick did here. She said the delegation clause, like any other contract, you have to look at whether defendants can enforce it. And the district court, or the trial court, did not do that here. It enforce the delegation clause without considering whether defendants have any authority to enforce it, and that was a reversible error. And you only get to that question about the delegation clause if Section 2 doesn't apply. And counsel raised the argument that New Prime is only a Section 1 case, but if you read New Prime, it is super clear that it is talking about Section 1 as an exception to Section 2, and that Section 2 is what provides the mandate for courts to enforce arbitration agreements, and the court must decide whether the dispute falls within the bounds of Section 2, either because it doesn't fall within Section 1 or because it doesn't fall within the plain language of Section 2 before it compels arbitration. And in New Prime, the court actually cited a 1956 Supreme Court case called Barnhart, where it was a Section 2 case. It was about the plain language of Section 2 and whether that applied. And the court said before compelling arbitration under Section 3 of the FAA, you have to look at whether Section 2 applies. And the court looked at the text of Section 2 and did that analysis. So New Prime is a case about how if the FAA doesn't apply, courts lack authority to compel arbitration. And that's exactly what we're arguing here and what the trial court needed to address. Finally, I want to address the Integrated Health Services case. It was a holding in the case. The court did need to decide whether it could decide the question or whether the arbitrator could decide the question. And it held that it could decide the question. It did put that in a footnote, but it went ahead and decided the question, which is what we're arguing here, that the non-signatory question is for the court and not the arbitrator. And that would not run afoul of Supreme Court precedent. And in fact, many federal circuit courts have held that the non-signatory question is one for the court to decide. And that's because it's a question about whether a contract exists between the parties to the agreement, and that question can only be decided by a court because it's a question of formation. And so and one other thing about this I want to address is the question about the JAMS rules. The incorporation of the JAMS rules is another way that parties can delegate arbitrability to the arbitrator. It doesn't make the delegation that the parties have done in their contract more of a delegation or more enforceable. It is just another way that parties can choose to indicate that they want to have the arbitrator decide questions of arbitrability. But whether they use the JAMS rules or they use explicit language that they want to delegate those questions of arbitrability to the arbitrator, the question is still whether that agreement was formed to do that and whether that agreement is enforceable. And the trial court erred here by not addressing those questions. It didn't address whether the delegation clause could be enforced by defendants who are not party to it, and it did not address whether the parties' dispute about arbitrability fell within the scope of the delegation clauses here, and it didn't address the argument that the active building delegation clause was illusory. And those were all errors because those were things that, whether you look at it as a formation question under Integrated Health Services or you look at it as specific challenges to the delegation clause as a standalone contract, the trial court was required to address those questions either way. And so for those reasons, we ask that you reverse. Thank you.
Appreciate the argument from both sides. The case will be under consideration and will be in recess. Thank you.